slides just to indicate what a moot is all about. So, can we go to the next one? What we've got is a situation where, as the Master of Ceremonies has said, we're looking at a simulated court case. Let's start with the word moot, which is a very peculiar word. We talk about a moot point, which is a point which is arguable. You can dispute the particular point concerned. So what we have is a simulated court case where there's an argument between two sides, basically. A legal moot is an oral argument by students on a legal issue or a number of legal issues arising from a given set of facts. So what we've got is the facts before you, which you've got in the handouts that have been circulated, show what the factual basis is for this particular moot. The students have to assimilate those facts, get familiar with the facts, then start researching to see what are the pertinent points of law that arise from those facts. Having decided that, they then apply the law to the facts and come to a conclusion relating to the particular point concerned. So the moot court is a court where we expect the students to behave like they would in court, lawyer-like. You can see that they've got gowns on, they've got this peculiar white thing hanging around their necks as well, called a jabot. But nonetheless, that's the formal thing that we expect from students. We've got the judges who have been introduced. Basically, with a moot, what we have is a situation where the speakers are divided into two teams. Now, what you've got before you today is a prosecution moot. So the prosecution is going to level charges against two accused people, a general and a colonel. And on the other side, we've got the people defending the two accused people. So you've got a prosecution argument followed by defense. Now, during the course of the proceedings, the judges themselves will be probing the arguments that are going to be presented by the students to see whether they stand up to close scrutiny, to see whether they're valid. And another thing that really one needs to watch out for in terms of acquiring legal skills is what happens when the judge asks a question. Now, you've prepared your argument, you've got a very systematic, cohesive argument that you want to adhere to. But now a judge has asked a question right in the middle of your argument. So you've got to answer the question, listen to the question, answer the question, but then get back to your argument. So you can't be thrown off track as a result of the interventions from the actual judges. Just to sum up, really what we have here is now mooting is an essential part of any legal education program. We need to get people to practice advocacy skills, to practice skills on analysis, on how to put together an argument, how to actually put forward a persuasive argument in the circumstances. So that's what the students are learning as a result of this exercise. So those few words are just by way of introduction to what mooting is all about. I'm going to hand over now to the Master of Ceremonies for the next portion of the setup.
Thank you very much, Professor Felton, for giving us a background of what a moot court session is about. Now, without wasting much time, I'd like to invite Advocate Mahere, CJ, small c, small j, for purposes of this session, to give us a very quick explanation of what international humanitarian law is all about. This particular case is based on international humanitarian law, and Advocate Mahere is going to give us a very brief description of what this area of the law is all about. Thank you.
Thank you. Now I'm going to go into my presentation and it is going to be brief, but before I get into it, I just want to say that because of mooting, right at the start of my career, I got exposure and managed to work in the UN International Criminal Tribunal for Rwanda. I then moved on to work at the International Criminal Court just because of these simulations that these students are doing. So I take very seriously the mooting program at the University of Zimbabwe. And funny enough, Professor Felter was my mooting coach. That's how old he and I are. So I'm just emphasizing that this is not just play court. It is real court, and it really prepares students for what they're going to face in the future. Now I'll come to the subject matter of today's moot. The body of law that the students are going to be arguing in is a body of law called International Humanitarian Law. This is the law that's practiced at tribunals such as the ICTR, the UN ICTR, and the International Criminal Court. In short, it's the law of war. We know that laws, or when wars take place, it's not a jungle. There are rules that regulate the commanders and the armies that are involved. So IHL, as it's sometimes commonly known, is a set of rules which seek for humanitarian reasons to limit the horrible effects of armed conflict. It's not the case that when a war happens, you can kill everyone at all costs. The purpose of the law is to protect persons who are no longer participating in the hostilities and restrict the means and methods of warfare. Civilians are to be protected. Serious violations of international humanitarian law constitute war crimes, and in certain cases, crimes against humanity as well. The main sources of international humanitarian law include the Geneva Conventions, with which I'm sure many of us will be familiar. These are a series of international treaties concluded in Geneva between 1864 and 1949 for the purpose of imposing constraints on the way in which wars are fought. The Geneva Conventions also ameliorate the effects of war on soldiers and civilians, and in addition to the 4 conventions themselves, there are 2 additional protocols to the 1949 agreement, which were approved in 1977, which add a few more clauses to the 4 conventions. We also have what's known as the Rome Statute, which is the treaty that governs the law applicable to the International Criminal Court, which is the main international court that's constituted to deal with war crimes, crimes against humanity, genocide, and in certain cases, the crime of aggression. After a conflict has ended, an international criminal tribunal may be set up in a country to deal with alleged war crimes committed during a conflict. This is what we saw, for example, in Rwanda and the former Yugoslavia, where a specialized UN tribunal was set up after the genocide to try those who were most responsible for the offenses that were committed there. So the moot today will involve the prosecution of General Sharp and Colonel Hatchett before a specialized international tribunal. They're alleged to have committed war crimes and killed civilians, destroyed civilian property in the town of Prado. We'll also look at the execution, and they're also guilty of the execution of combatants who had surrendered. There's a handout which you will see floating around, which has the full facts of the case, but you'll be able to derive the facts from the exchanges and the argument that our mooters will present today. So thank you very much for coming, and we'll get straight into the moot. Henceforth, I'm Mahere, CJ. And before we go into the actual hearing proceedings, we're going to watch a short video that discusses the law of war. It will be just 4 minutes, Professor's telling me. So just watch it so that you're able to follow just in broad brush strokes what today's moot is about. Thank you.
Since the beginning, humans have resorted to violence as a way to settle disagreements. Yet through the ages, people from around the world have tried to limit the brutality of war. It was this humanitarian spirit that led to the first Geneva Convention of 1864 and to the birth of modern international humanitarian law. Setting the basic limits on how wars can be fought, these universal laws of war protect those not fighting, as well as those no longer able to. To do this, a distinction must always be made between who or what may be attacked and who or what must be spared and protected. Most importantly, civilians can never be targeted. To do so is a war crime.
When they drove into our village, they shouted that they were going to kill everyone. I was so scared. I ran to hide in the bush. I heard my mother screaming. I thought I would never see her again.
Every possible care must be taken to avoid harming civilians or destroying things essential for their survival. They have a right to receive the help they need.
The conditions prisoners lived in never used to bother me. People like him were the reason my brother was dead. He was the enemy and was nothing to me. But then I realized that behind bars, he was out of action and no longer a threat to me and my family.
The laws of war prohibit torture and other ill treatment of detainees, whatever their past. They must be given food and water and allowed to communicate with loved ones. This preserves their dignity and keeps them alive. Medical workers save lives, sometimes in the most dangerous conditions.
Fighters from both sides were wounded in a deadly battle. We were taking them to the nearest hospital. At the checkpoint, a soldier threatened us to treat his men only. We were running out of time, and I was afraid that now all of them were going to die.
Medical workers must always be allowed to do their job, and the Red Cross or Red Crescent must not be attacked. The sick or wounded have a right to be cared for, regardless of whose side they are on. Advances in weapons technology have meant that the rules of war have also had to adapt. Because some weapons and methods of warfare don't distinguish between fighters and civilians, limits on their use have been agreed. In the future, wars may be fought with fully autonomous robots. But will such robots ever have the ability to distinguish between a military target and someone who must never be attacked? No matter how sophisticated weapons become, it is essential that they are in line with the rules of war. International humanitarian law is all about making choices that preserve a minimum of human dignity in times of war and make sure that living together again is possible once the last bullet has been shot.
Right, this court is now in session. Counsel will now take appearances.
If it pleases this honorable court, my ladies, my lords, my name is Miss Patience Ngoma, and with me is my co-counsel, Mr. Kudakwashi Shamu. And together, we appear as counsel for the prosecution in the matter of Prosecutor versus General Sharp and Kendall Hatchett.
My ladies, my lords, and may it please the court, appearing as counsel for the defense, my name is Ms. Sarai Chinyama. Appearing with me is my colleague, Mr. Ichi. Thank you. Thank you very much.
If this honorable court pleases, I will then proceed to lay out the structure for submissions. We propose to structure our submissions in the following manner. Firstly, from the facts at hand, we shall establish the nature of the conflict, especially that the conflict started off as a non-international armed conflict and then it graduated or escalated into an international armed conflict. Secondly, we shall lay out the charges as leveled out against the two accused persons. I will deal with the first charge, which is based on Section 8(2)(b)(4) of the Rome Statute, which is the war crime of intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects, which would be clearly excessive in relation to the concrete and direct overall military and advantage anticipated. The basis of this charge is found in paragraph 13 of the facts, wherein it is stated that the Brunelian forces launched an attack that led to the death of only 35 soldiers and 73 civilians. My co-counsel, Mr. Kudakwashi, will deal with the second charge, which is based on Section 8(2)(b)(6) of the Rome Statute and is the war crime of killing or wounding a combatant who, having laid down his arms or having no longer means of defense, has surrendered at discretion. It is our prayer that this honorable court makes a finding that the two accused are guilty as charged in the charge sheet. I will now turn to deal with my submission. It is the submission of the prosecution that the nature of the conflict was a non-international armed conflict that then developed into an international armed conflict.
What stage did this occur, Count? At what stage did that occur?
Indebted, my lord, if I may draw the attention of this honorable court to paragraph 6 of the facts, wherein the Prague Liberation Army killed 43 trained soldiers of the Brunelian forces. It is the submission of the prosecution that then this was no longer just a group, it was an organized liberation group that was able to orchestrate a well-organized attack on trained 43 soldiers and killed 43 soldiers. It is the submission of the prosecution that this non-international armed conflict then escalated into an international armed conflict in paragraph 8 of the facts on record. In paragraph 8 of the record, it is stated that the Pradelian forces then intervened to protect the Pride Liberation Army. That is when the Pradelian forces intervened into the army, into the conflict. By that very nature of the intervention, an international armed conflict was sparked.
Counsel, do you have a definition for an international armed conflict? And if so, what's your authority for that legal definition?
Indebted, my lady, for the question. In the case of Prosecutor versus Tadish Appeals Chamber decision of the International Criminal Tribunal of Yugoslavia, case number IT 94-1 AR 7235, it was stated that an international armed conflict is a conflict that takes place when two high contracting states take place. I'll take that again. An international armed conflict is a conflict that takes place when there is resort to armed conflict between two high contracting states. So in this case, it is the submission of the prosecution that in paragraph 8 of the facts on record, when the Pradelian armed forces intervened into the conflict that was taking place between Pride Liberation Army and the Brunelian forces, an international armed conflict then erupted.
Counsel, is it not the case that there were two simultaneous conflicts taking place? A policing operation against the PLA fighters, who were in fact Brunelians, who had actually committed atrocities in Brunelia. So the government of Brunelia had a perfect right to actually suppress them in the light of their terrorist activities that they'd engaged in. Now that was happening simultaneously with the two armies of the two countries coming into conflict. So surely you've got a situation where you've got two types of conflict merged together almost. But the one is an international armed conflict between the armies of two states, and the other is a policing operation against the PLA fighter.
Indebted, my lord, for the question. It is the submission of the prosecution that when the Pradelian army actually intervened into the conflict, it took in or absorbed the Pride Liberation Army into its forces.
Did they become soldiers of the Pradelian army, or were they still liberation fighters?
It is the submission of the prosecution, my lord, that at that stage they then became one with the fighters of the Pradelian army. They then fought alongside each other, and that is when they were then absorbed and the force became one. Now that the prosecution has established the existence of an international armed conflict, I'll then tend to deal with the charges. The first charge that I will deal with is the charge is based in the Rome Statute, Article 8(2)(b)(4), which is intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. I will first deal with the charge is leveled against Keno Hatchet. The first element of this crime is the perpetrator should have launched an attack. From the facts of the case, it is apparent, or it is common cause in paragraph 12, that indeed an attack was launched.
Yes, that's taken as read. Go on.
Indeed, my lord. And then, the second element of the charge is that the attack was such that it would cause incidental death or injury to civilians or damage to civilian objects.
Sorry, Counsel, before you move on to that next element, I just want you to address me, please, on the question of whether or not there was a direct military advantage to be gained, such as would have excused the accused on this particular charge.
It is the submission of the prosecution that whether or not there was a direct military advantage that was being anticipated is not really at play here. What is at play is the attacks and the proportionality principle which then comes into play, that when the attack was launched, there was no precaution that was taken. That is why there's a collateral damage.
Counsel, that's not the point. The point is that we're looking to measure the excessive nature of the civilian casualties measured against the military advantage on the other hand. So how do we do this? How is this measured?
Indeed, my lord. In order to measure this appropriately, I would draw the attention of the Honorable Court to the casualties that we suffered. More civilian casualties were faced by the soldiers. In effect, 73 civilians died in excess over 35 soldiers dying in the attack.
But surely the point is that the intelligence that the accused had was to the effect that there were PLA fighters hiding together with Pradalian soldiers here. Isn't that the key point? And given that one of the elements of the crime is that the killings have to be excessive in relation to the direct overall military advantage to be gained, would you not say that the military advantage to be gained was significant in relation to those who actually died?
And this is my lady further question. It will first be the submission humbly of the prosecution that the military intelligence that, or the military knowledge that was given to Colonel Hatchett at this point was in fact flawed. This it can be taken from the fact that more civilian casualties actually took place than the civilian attacks were on high scale than the soldiers who died. So it is the proposition or the submission of the prosecution that this attack was not proportionate, or the direct military advantage that is being anticipated was not.
Counsel, you said the intelligence was flawed. Would it then not suffice to say that the colonel and the general did not know that there would be civilians? And if they did not know, what is the implication of that?
Because remember, intention is a key element of this.
The third element of the crime is that the perpetrator knew that the attack would cause this incidental loss.
It is the submission of the prosecution, my lord, that when we are taking this element into account, the four fundamental important aspects of international humanitarian law are supposed to be taken into account. And those are the principle of distinction, the principle of proportionality, the principle of military necessity, and the principle of precaution. If only Colonel Hatchett had taken precaution to at least inform the civilians before doing it, or before taking part in indiscriminate bombing in the civilian town, then at least the civilian casualties would have been prevented. So it is the submission of the prosecution that the Colonel Hatchett had a duty of precaution. He first had to make sure that he at least informs the civilians that were in the town before bombing.
Counsel, can we not say that they exercised precaution by issuing those leaflets, giving them an opportunity to surrender and to tell them that an attack was coming?
Indeed, my lady, for the question, it will be the submission of the prosecution that yes, leaflets were dropped, but then if we're now taking into account the facts that are on record, leaflets were dropped to address the soldiers, PLA fighters that were still in the civilian town, not specifically the civilians. Secondly, my lady, only 5 hours were given, and 5 hours were not really reasonable notice to inform people to leave a town just by dropping off leaflets.
It's a small town, and presumably those leaflets could have been acted upon really quickly. I don't see the point here, but anyway, I think your time is up.
Thank you, my
So, Counsel, just give us one sentence in summation before we move on to your co-counsel.
Indeed, my lady. It is the submission of the prosecution that this honorable court make a finding that Colonel Hatchett is indeed guilty of the crime of causing incidental attacks or making an attack that caused collateral incidental damages and injury to civilian properties, and that they may be found guilty as in relation to the Rome Statute and the Geneva Conventions.
Thank you. Thank you very much, Counsel. We will now hear from the defense on this particular count. Ms. Chinyama, we will take you now.
My ladies, my lords, and may it please the court, I'll be addressing this court on the nature of the conflict together with charge 1. I turn now to the nature of the conflict. We submit, my ladies and my lords, that the nature of the conflict in this case is not particularly defined in one or in whole. We refer the court to the authority as given by the ICTY in the Tadic Appeals Chamber decision, where they likened a conflict to a chameleon, which changes shape and color determining on what it is associated with. It is the defense submission that with regard to the first charge, it was indeed an international armed conflict which involved the Bronolian forces, the Pridelian forces, together with the PLA. I turn now to address the court on charge 1 as leveled by the prosecution. With regards to charge 1, both the first accused...
Sorry, Councillor, you indicated from the Tadic judgment that this was an internationalized conflict of some sort, that it kept changing. You say in this instance it was an international armed conflict?
With regards to charge 1, my lady. Yes.
Charge 1, okay. At which point did it become an international armed conflict in your submission?
As was highlighted by the prosecution, we concede that at the moment of paragraph 13, when there's the attack that resulted in the civilian death, it was an international.
Okay, so that aspect is common cause.
Yes, my lady. I'll proceed with my submissions. As I was submitting, my ladies and my lords, with regards to charge 1, both the first accused, Colonel Hatchett, and the second accused, General Sharp, plead not guilty to this charge. I'll address this court first on the charge as leveled against Colonel Hatchett. The crime that is leveled against Colonel Hatchett by the prosecution is as defined in section 8, 2B4 of the Rome Statute. My ladies and my lords, as is tried, that to warrant a criminal conviction, there must be fulfillment of all the essential elements of the crime. For purposes of time, the defense will take issue with 2 elements of this crime, primarily element number 2 and element number 3. But because element number 3 dispenses of the need to address element number 2, I'll address this court first on element number 3. My ladies?
Sorry, Counsel, just to follow your argument, so are you suggesting that there was intention in this case?
No, my lady.
Okay.
Element number 2 is the element that deals with the question of intention, and the defense takes issue with that also.
Thank you.
As I was saying, I'll address the court first on the third element, which requires that the perpetrator knew that the attack would cause these incidental civilian losses and harm to civilian objects. It is the submission of the defense, my ladies and my lords, that the perpetrator, in this case, Colonel Hatchett, did not know that the attack would result in the death of these civilians and the destruction of civilian objects. When we refer to the facts, my ladies and my lords, we find that in paragraph 12, Colonel Hatchett relied on intelligence information before launching this attack. He found intelligence information. It highlighted areas where it was likely that the PLA fighters, together with the Pridelian soldiers, were, and only attacked those particular areas based on the intelligence that he found.
The word likely disturbs me. I mean, in the circumstances, it's likely to have those soldiers present. Surely that's not a sufficient basis for mounting an attack. If it's only likely to have those consequences.
I beg your pardon, my lord, I actually stated the statement wrongly. When you read the last 2 lines of paragraph 12, it says, Colonel Hatchett ordered the Air Force to bomb the areas of the town which intelligence information indicated were areas where the PLA fighters were hiding together with the soldiers. There was an element of certainty. It is the submission of the defense, my ladies and my lords, that the element in this case does not require constructive knowledge, it requires actual knowledge. The perpetrator must have actually known. He must have known that it would result in the deaths of civilians. He must have known that civilian objects would be destroyed.
Counsel, what authority supports your contention that constructive intent would not suffice as a criterion?
If a ladyship could rephrase the question.
Why do you say actual knowledge as opposed to constructive knowledge? Why is constructive knowledge not applicable in this case? And what's your authority for that submission, if any?
My lady, I would submit that a plain reading of the Rome Statute as it is presented would be my authority in this case. When you read, for example, Article 28 of the Rome Statute, it says the perpetrator must have known or should have known. And in this case, Article 8 only says must have known. And therefore, a plain reading of the statute would indicate that in this case, there is need for actual intention and not constructive knowledge.
You can proceed.
The council had a bit of difficulty with that submission. There's a difference between must have known and did know. So surely we're talking, your submission is that what we require is actual knowledge, full knowledge.
Yes, my lord.
In the circumstances. Didn't Hatchett have any inkling that the bombing of this small town was going to actually result in civilian casualties? Given the outcome of the bombing, in the circumstances concerned, did he not really anticipate that civilians were going to get killed or injured? An orphanage was taken out by the bombing. A hospital was bombed. Surely, in the circumstances, Hatchett must have had some knowledge that this was going to occur. Even if our submission is correct, that all we have to require actual knowledge on his part, we take that as being correct for the time being. Did he have knowledge? Did he not have some knowledge in his mind that this bombing was going to result in huge civilian casualties?
Indebted, my lord, it is the defense position that he did not know in this case. The colonel was under pressure. At paragraph 11, we see him sending in ground forces, and we see the forces being directly attacked, resulting in him losing 50 members of his force. And in the heat of the moment, relying on intelligence information about particular areas where they were, and surely he could not have known. He did not know.
Is it your submission then, and I think just to build on from what my brother judge has raised, that your client believed that there were no civilians in this town, that everybody was either participating directly in hostility or a combatant?
No, my lady. It would be absurd to suggest that my client believed that there were no civilians in this town.
So surely he knew.
He did not know that there were civilians in the particular area. And the charges leveled by the prosecution is with regards to the attack that took place on this area where intelligence had indicated that the fighters were hiding.
Counsel, I'm taking issue with your submission because when you look at the facts, there is nothing to indicate or to support your averment that you did not know that those areas had civilians. It's a small town. Where would the civilians have gone? Can you clarify that for us?
And to add to that, when we're talking about bombing, yes, we're wise after the event. We know how many casualties have in fact been sustained here. Very bad casualties of children and people in hospital. But nonetheless, what we're saying here is that when you go in and bomb a civilian town, there are bound to be civilian casualties. And surely, therefore, your client must have anticipated, or did anticipate, that there would in fact be civilian casualties.
With respect, my lord, it appears your question seems to suggest that my client should have known.
That he did know. He, in the circumstances concerned, civilian casualties were inevitable, and therefore he must have known that. He did know.
My lord, it is the defense submission which we strongly stand by, that he did not know, and that because he did not know, there was no violation of IHL.
So, counsel, please can you offer us a summation of your arguments so that we can move on to the next charge for the prosecution? Thank you.
Indebted, my lady. With regards to charge 1, it is the submission of the defense that my client, the second and third requirements were not satisfied, in that my client, Colonel Hatchett, did not have intention to launch the said attack, and therefore there was no crime in that regard. And therefore, by extension, my lady and my lords, General Sharp would also be innocent of the same crime. However, should this court find that Colonel Hatchett should have known or knew in the circumstances, it is still the submission of the defense that General Sharp would still not be guilty of the same crime, because in paragraph 15 we are told that he was only told of the attack after the fact, and therefore it is clear in the facts that he actually did not know, and therefore with regards to General Sharp.
There is a problem in the sense of the nature of the orders that were handed down by General Sharp originally to the Grenadier forces. What was the order that he gave?
As presented,
how do you interpret that order?
Their orders were to track down and kill all PLA fighters.
So isn't that exhorting the troops to engage in indiscriminate warfare?
we submit, my lord, that it is not. The order basically meant that they should end the terrorist crimes that was taking place, that was
at all costs, the PLA fight.
with respect.
At all costs, even civilian casualties.
The order did not indicate that they must kill at all costs, just say try and kill.
Thank you, Ms. Chinyama. We'll move on to the prosecution submission on the second charge.
If it pleases this honorable court, my ladies and my lords, I propose to structure my submissions in the following manner. Firstly, I take issue with certain issues that have been raised by the defense, and I feel to be a grave injustice to this honorable court if the prosecution does not rebut a specific aspect that has been highlighted by the defense counsel, in particular with regards to the element of actual knowledge. Thereafter, I shall move to deal particularly with the second charge, which is the war crime of killing combatants who are rendered or decombat. I shall deal firstly with the first aspect, which is the rebuttal by the prosecution. My ladies and my lords, the case of Prosecutor Mrs. Halilovic has clearly established that the citation is of November 16, 2005, paragraph 66 of the trial chamber, ICT1. Yes. In which the Honorable Court established that the fact that a military commander will most probably be part of an organized structure, highly organized structure, is sufficient in itself to take into account the aspect of actual knowledge. In this regard, I shall place before this Honorable Court further knowledge, in particular the Yamashita Doctrine, or the principle of Medina, in which, once again, the Japanese general was held to be accountable for the actions of his subordinates. Indeed, this is the precepts and the principles that are enshrined when one takes a microscopic analysis of Article 86 of Additional Protocol 1, my Lord and
However, Counsel, surely the issue is the distinction between actual and constructive knowledge. So this is not knowledge in general, but this is actual knowledge.
Yes.
What evidence is there that the accused had actual knowledge?
Most indebted, my lady. Once again, if I may refer this Honorable Court to the case of Prosecutor Mrs. Corbett Circus, Trial Chamber of February 26, at paragraph 427, in which it was established that circumstantial evidence can be taken into account insofar as actual knowledge is concerned. So based on this, the prosecution humbly submits before this Honorable Court that this Honorable Court makes a finding that the aspect of actual knowledge as to the third essential element of the first charge has fully been discharged.
What are the circumstances?
Most indebted, my Lord.
That lead you to that conclusion?
This is based on the movement, firstly, of the soldiers. They cross over from Brunolia into Predalia. It is common cause.
Counsel, we're talking about an incident in private, right?
Yes.
Let's just stick to that point.
Yes, most indebted, my Lord. Once again, to answer your question.
Did he have actual knowledge that there were going to be heavy civilian casualties?
Most indebted. Yes. This therefore follows into the core principles of international humanitarian law, in particularly the principles of necessity, the principles of proportionality, and of distinction. Indeed, they dropped the leaflets, as per the record. Indeed, they sent initially the troops as a way of precautions. But the main question that follows is, was it enough? Taking into cognizance the fact that these soldiers were already outnumbered, there was no military advantage to be anticipated because they had already won the war already. This is therefore with regard to the first charge, and without taking this Honorable Court's time, my Lord, or humbly move.
You press on with the second charge.
Yes, that is my submission. Most indebted, my Lord. I shall be dealing particularly with the second charge, which is the war crime of killing or wounding a person who is rendered or decombat. In this regard, I shall conduct a microscopic analysis of each of the essential elements and prove before this Honorable Court that these essential elements have been satisfied, and move that this Honorable Court finds the accused guilty of both charges. In this regard, I shall deal with the first essential element, my Lord, which is that the perpetrator killed
or injured one or more persons, which is common cause. This is based on paragraph 14 of the record, in which most indebted, my lord. The second aspect is that such persons or persons were all decombat. The next question is, what is it that we're talking about when we're saying a person is all decombat? We're saying these are combatants who are no longer actively participating in hostilities. Once again, drawing on the noble principle of distinction, which is that people who are not actively participating in hostilities should not be the object of attack.
The facts are clear that the incident in question happened before Colonel Hatchett could do anything about it. Why should this court indict a person or reprimand a person who had no powers in the circumstances?
Most indebted, my lord. I'll draw this honorable court.
That after Colonel Hatchett found out, he took an immediate action.
Most indebted, my lord. All right, to answer your first question.
This is the action of a responsible commander on the spot. As soon as he finds out that he surrendered, PLA fighters had actually been exterminated, he takes decisive action. He sends his soldiers home and demands that they be disciplined.
Most indebted. All right, to answer your first question, the authority is premised on Article 28, particularly A of the Rome Statute, which is the mode of responsibility when it comes to commanders or superiors, which therefore brings about the fact that Colonel Hatchett was the person who was on the ground. We therefore have on one side Colonel Hatchett, who is actively participating in hostilities together with the Brunelian Armed Forces. This therefore means that he was aware of the actions of his subordinates. And then to answer the question...
Let's get to the point.
Yes.
What we're talking about is, was he aware of the specific action of actually killing these PLA people that had actually surrendered?
Most indebted, my lord.
And we need an answer to that. Was he aware, or should he have been aware, that this was about to happen? Did he have any foreknowledge of the fact that this was going to happen?
Most indebted, my lord. Once again, I'll draw this honorable court's attention to the atmosphere that was prevailing. We have the Pradarian Liberation Army, which had been a cancer to the Brunelian government. They were given clear orders, which is to exterminate all PLA fighters. As a reasonable commander, it was upon, the onus was indeed upon him to ensure that he had control over the actions of his subordinates. This therefore draws us basically even on the charges, on the type of orders that were given by the general himself to exterminate, not to capture, to totally annihilate the PLA cancer on the Brunelian government. This therefore shows that he should have been...
Sorry, counsel, whatever General Sharp said at the beginning, what we're concerned about is what happened at the critical point in time when Hatchett discovered that these soldiers had actually got out of line and killed the surrendered PLA fighters. Did he know in advance that this was going to happen? Or should he have known in advance that this was going to happen?
It's most intentional, my lord. It is the prosecution's submission that Colonel Hatchett had an obligation, indeed, as a trained colonel, it was upon him to know. Indeed, he should have known. Based once again on the hostile environment that was occurring. The fact, therefore, is that he should have known that his fellow soldiers would be emotional. He should therefore have taken this into cognizance before moving into the town as then occurred. Because this is what actually then led to the death of these 12 innocent PLA fighters.
Yes. The problem, though, is that Hatchett, as soon as he finds out that his soldiers have done these things, orders them to go back to Brunelia and be disciplined. Surely this is not a person who knew in advance that this was going to happen. It's just illogical. Why would he have actually taken this action in the circumstances against his soldiers? If he'd known in advance that they were going to do it, he would have stopped it.
Most intense, my lord. To answer your question, my lord, I'll humbly state that prevention is better than cure. What we have in this case is Colonel Hatchett merely tried to exonerate himself by sending these people back. Indeed, he has satisfied one of the essential elements insofar as command or superior responsibility is concerned, which is taking action, decisive action on people who have committed atrocities. But once again, it is the prosecution's submission, humbly before this honorable court, that even that action was taken when it was merely too little, too late. Indeed, once again, falls humbly on the purpose and the precepts of international humanitarian law, which is to bring humanity to law. Indeed, we cannot eliminate the Schedule 4, but indeed the onus is upon the commander as a superior, as enshrined in Article 28A, Article 85, and Article 87 of Additional Protocol 2.
So that's your submission in respect of Colonel Hatchett. What about your submission in respect of General Sharp?
Most indebted, my lord.
Quickly, please, you're running out of time.
Thank you. General Sharp falls within the purview, within the ambit, once again, of Article 28A of the Rome Statute. This is premised primarily on the nature, the type of order that it gives. As I've already alluded to in my submissions, my lord, he gives an order to exterminate the PLA army, to exterminate the liberation movement. This therefore knows that...
Sorry, Council, quickly, did that encompass killing surrendered PLA fighters?
Most indebted, my lord.
Was he actually intending that even if they surrendered, they would be massacred? Was that the intention on the part of the general? Or was it just an emotional outburst that we've got to get these people because they're causing havoc in our country? So we've got to pursue them, track them down and kill them. But does that also encompass killing surrendered soldiers?
Most indebted, my lord. I'll humbly make the submissions that were also made by the prosecutor in the Yamashita case. With regards to General Sharp, he's not being charged because of what he did necessarily, but merely because he's the commander. This is the aspect that falls within the concept of command responsibility, my lord.
Thank you, Counsel.
Most indebted, my lady.
We'll now hear from the defense on the second charge.
May it please this Honorable Court, counsel for the defense dealing with the second charge given by the prosecution. I propose to structure my submissions in two parts. Firstly, I will show how Colonel Hatchett and General Sharp are not guilty of the charge given by the prosecution. And secondly, the second crime was erroneously charged against Colonel Hatchett and General Sharp. The submissions of the prosecution paint a very contentious picture. Now, to deal with my first issue, the reality of the facts as presented by the prosecution, married to the law as it stands, establishing the circumstances of this case, is digressing in a shockingly alarming level. That they proved their case to a completely reasonable, beyond every reasonable doubt, is sublime mysticism. Let's assume, or in fact, Colonel Hatchett and General Sharp are not responsible or criminally liable for this war crime, because General Sharp ordered the killing of these individuals. I had the prosecution going, extermination, annihilation, extermination. These people are not insects. General Sharp was clear in his instructional order. He said he was going to order the killing of the PLA fighters. Now, according to the ICTY's codish in seconds, ordering...
Counsel, just so I can follow your argument, which elements of the crime do you say have not been satisfied? And then you can address some of the authorities thereafter.
Most indebted, my lady. The last element brought about by the prosecution dealing with the knowledge of an attack of the people who are in Odikoma. This has not been satisfied. And the other element which the prosecution failed to mention deliberately because they know that at this point, looking at paragraph 12 of the fact and 10, there was not an international armed conflict. As my co-counsel established, the nature of the conflict as per the Tadic case can change like a chameleon, and according to these circumstances, there was a non-international armed conflict. I'll proceed with my submission.
Is it not the case that the PLA fighters went into Prado to hide together with some Pradilian forces? On what basis then can you say the conflict had changed in complexion?
Thank you, my lord. I'll draw the attention of the court to paragraph 13. Forgive me, to paragraph 9 of the of the record, we see here that there were leaflets dropped. Now, when we look at the facts also, we can see that there is a moment in the facts where there are only PLA fighters against the Pronolian soldiers, where these individuals were in Odikomba and they were executed. There were no...
So let me just pause you there. What's the relevance of these leaflets, given that they were leaflets addressed to legitimate military targets?
Most indebted, my lady. These leaflets speak to the intention and the might of Colonel Hachit. He had no intention of ensuring that there were going to be war crimes committed, because at first, even initially...
The evidence suggests something to the contrary. The evidence suggests that he wanted to notify, in fact, perhaps scare the fighters, but he did absolutely nothing with respect to the civilians. Is there any evidence of your client giving those leaflets to civilians, asking them to vacate, consistent with the doctrine of which espouses the need to take precautions?
Most indebted, my lady, I humbly submit and direct the court to the attention that I'm dealing with charge 2 of executing PLA fighters who were in Odikomba. The civilian issue had been dealt with by my co-counsel.
Surely there's no doubt that this was an international armed conflict. When two armies of two states directly come into conflict, they're fighting against one another. And the Pradalian Liberation Army personnel have been absorbed into the armed forces of the Pradalian state, as it were. At that stage, surely we've got a full-scale international armed conflict.
Most indebted, my lord, I will direct this honorable tribunal to paragraph 14 of the record, where we see that after the bombardment, the remaining PLA fighters surrendered to the Pronolian forces. Now, these PLA fighters were alone, and they were not Pradalian national forces. They were only Pronolian citizens who formed themselves into a liberation force which attacked the Pronolian soldiers.
So are you suggesting that after the surrender of these people, they changed their status from being part of the Pradalian army into people that are now PLA fighters again and are not combatant?
That is accurately the defense submission, my lord.
Yeah. Go. On what basis do you say that?
On the basis that the moment this clash, the moment they surrendered, they could not have been taken as prisoners of war, because there is only a status afforded to combatants. And given that these individuals, according to Article 43,
you can't execute surrendered prisoners.
They cannot be executed.
Yes.
I agree with you on that issue, my lord. I'm saying that the fact that they were executed does not mean that they were combatants. They were fighters. Combatants are national armed forces of the country. These individuals were alone without the support of the Pradalian National Armed Forces.
Your lead counsel said that these were combatants at one point. Do you agree?
I agree, at one point.
At one point?
Yes.
So is it your submission that when they surrendered, they ceased to be combatants?
The moment the PLA people, armed fighters, surrendered to Pronolian soldiers, there was a non-international armed conflict between them, on paragraph 14.
If they surrendered, then what conflict is there to talk about? I'm failing to follow your line.
After they were captured, the PLA fighters only.
Look at the definition of an armed conflict in Prosecution versus Tadic, which is trite now. You certainly have to have an armed conflict taking place, certainly between certain parties. You can't just have fighters on their own and call that an armed conflict.
Most indebted, my lady. What I mean to say is the rules and regulations of a non-international armed conflict pertaining this charge would come into play when we're dealing with charge 2.
Do you have any laws of war applicable once the war is over, effectively?
Most indebted, my lady. The war at this point was not over, because as we see on paragraph 16 of the record, the war rages on until there is a settlement to bring this issue to this honorable tribunal. So only individuals surrendered during a battle, not the entire war.
Yeah, so with that battle, I'm just keen on the characterization and your supporting authority for it. During that battle, who was fighting whom and what was the applicable law?
Most indebted, my lord.
If I say that the war happening somewhere else had an effect on the law applicable where there was no war taking place? I want to follow your argument and be fair to you.
Most indebted, my lady. If that's the court's view, then there is no conflict. If there is
no view,
asking for
we're asking you for submissions and for you to assist us.
Thank you, my lady. if I might consult with my co-counsel for a brief moment. Most indebted by the, given that these individuals had surrendered and that there was no conflict anymore, the application of IHO would not apply, and to that effect, that means that this charge would be irrelevant.
Counsel, if the court, the tribunal finds against you and finds that this is indeed an international armed conflict, what are your further submissions?
Most indebted, my lord.
On the defense of the two charged people.
I will deal with Colonel Hatchett. Given that the Honorable Tribunal will have found that this is an international armed conflict, we'll take a look at Article 28 of the Rome Statute, sub-article 1 and paragraph 1 of that point. Colonel Hatchett must have known or knew of the factors establishing the execution of these PLO fighters, and he may have done something to repress or prevent or institute disciplinary proceedings to ensure that these individuals, the Prenolian soldiers, when executed, the PLA fighters were admonished. And to that effect, we see from the facts that Colonel Hatchett was actually disappointed. He had no knowledge that the Prenolian soldiers were going to execute the PLA fighters who were captured. And to that effect, he instituted disciplinary proceedings to ensure that this wrong, this war crime, would not happen again, and it was wrong. Now, to deal with General Sharp briefly and to end my submissions, General Sharp's order was very clear. It was not supposed to be taken literally, and those individuals or Prenolian soldiers who took that order literally, it is not on General Sharp, it is on them. According to the ITC-Y Scottish and Segis, the prosecutor, ordering was taken as to mean that an order which attracts criminal liability must have been made by a person who is in authority, instructing the commission of a crime. General Sharp did not instruct the commission of a crime.
What did he instruct?
He instructed individuals of the Prenolian army to go and kill the PLA fighters. That's right.
To a person?
To a person, yes.
Right.
They
so,
did not...
I mean, surely the soldiers on the ground are going to actually interpret that literally. I'm a Prenolian soldier, and I've heard that my general has said we go and kill all the PLA fighters. We're going to do it. We're going to kill them wherever we find them, even if they've surrendered. We're going to kill them. We're going to exterminate them.
The defense does not find any contention with that fact. What the soldiers did was wrong. Men died, and that is not wrong. But what is wrong is trying to put it on General Sharp's statement, which was very clear and must not be taken literally by the soldiers, not General Sharp.
Thank you so much. Let's give all our mooters a massive round of applause. As you can see, we were all getting quite into it and trying to decide which side was winning, which side was more persuasive. So at this juncture, let me just express my huge thanks to all the students who participated in mooting. I guarantee you this is going to have a huge effect on your career. You're going to walk into a courtroom and have the confidence that some of your other peers may not have because you don't have, because they don't have this experience. So I really encourage any lawyers, law students who are here to please participate in mooting. We've got an international humanitarian law moot that's coming up, which we will participate against all the other law schools in the country, including Midland State University, Ezekiel Guti University, and Great Zimbabwe University. So please, we would like to raise the flag of the university very high there. We're the oldest and best institution when it comes to the teaching of law, so let's demonstrate that. Just some final words on mooting. I was very impressed with all the students and their ability to respond and deal with interventions by the judge. It's always a fine balance to try and protect and guard your client's interests while at the same time showing due deference and respect for the court. So well done to all of you for doing that. The strongest mooters will have a very sound grasp of the facts and the law. Very strong mooters will also anticipate the arguments by the other side. So if you're for the prosecution, you must also think to yourself, what is the counter-argument? Because once you think along those lines, you'll be able to preempt what judges are going to nail you on. You must also do case analysis at the start and see where your client's case is weak. As lawyers, we all get weak cases sometimes, or we all have instances where a certain aspect of our client's case is weak, and we have to be able to think strategically as to how that aspect of the evidence can be overcome. So always remember to do that as well. Teamwork, whenever you're participating in a moot where you present as a team, it's slightly different from court where you're often practicing as a lone practitioner. So make sure that you divide the work that you're going to do equally, and make sure that your arguments are internally consistent one with another, so that you're saying the same thing. So it doesn't sound like two people have spoken, but it's just one set of arguments flowing seamlessly into the next. You always remember to introduce the argument and to conclude it. So I think on that happy note, let me just confer with my other judges and make sure that I haven't left anything out. That is actually what the Chief Justice does. So all that remains is for me to thank you all for coming this evening and for supporting the Faculty of Law. Thank you so much. For being part of our presentation at Research Week today. It's been a pleasure to have you, and thank you.